There are lengthy tests and requirements that must be met to prove that a charitable status is deserved, governed by the Australian Tax Office. As the committee is also aware, charitable status is not a mantle readily handed out to any organisation merely claiming to be charitable. In appearing today before the Senate Economics Legislation Committee, it is important to recognise that the Church has undergone significant investigation and assessment to achieve the appropriate taxation exemptions that we have. Scientology is accepted as a religion around the world. In a few countries, the Church has been forced to litigate the issue of its religiosity, either affirmatively or in response to unfounded charges. Inevitably, the Church's religiosity has been upheld by the courts in these cases, and its religious bona fides have been unequivocally recognised. In relation to Australia, the 1983 High Court decision found that the Church met the criteria and as a result was then provided with tax concessions that apply to other religions. Following this decision by the High Court and other judicial bodies around the world, Scientology is considered by leading scholars and authorities to have established the standards regarding religious recognition that all religions must meet. For the benefit of the committee, I wish to draw your attention to the United States Internal Revenue Service investigation into the Church of Scientology. The investigation into the Church of Scientology was and remains the single largest in the history of the Internal Revenue Service. It not only involved the US Church, but all churches of Scientology around the world. This IRS examination included reviewing every single claim made against Scientology, reviewing every single flow of money within the Church, and reviewing allegations which have been raised in the last few months by Australian media outlets. Further, the New Zealand Inland Revenue Department granted Scientology charitable status in 2002 after their inspection of the Church, which lasted 10 years. In 2006, when the New Zealand Charities Commission was formed, it too gave the Church charitable status. In recent days, the Church has also become aware of disturbing allegations regarding taxation matters in Australia. These allegations were raised by a media organisation and involved commentary from a member of the Economics Legislation Committee. For the benefit of the committee, and given it relates directly to taxation, I wish to make the following comments. The allegations refer to the Church of Scientology in Australia and the United Kingdom, and the specific allegation that the entire UK operation is, quote, run out of South Australia, end quote. The facts are as follows. 1. The Church Association that is incorporated in South Australia, Church of Scientology Religious Education College Incorporated, was incorporated in 1976 and registered as the Corporation for Churches in England in 1977, a full 22 years earlier than the alleged incident in the media. The Church of Scientology Religious Education College has paid all corporate taxes on any surplus in accordance with the UK tax legislation. It receives no corporate tax benefit in the UK from being incorporated in South Australia. I wish to provide a copy of the statement that was issued by the Church clarifying the allegations and outlining correct details surrounding the matter. Mr. Chairman, I seek leave to provide this to the committee.
Leave is granted.
Thank you.
If the committee agrees.
Can I just, yeah, I'm happy with that, but could you also table your statement that you're reading from?
Yes,
it would be helpful
definitely.
for us as well.
Yeah.
Right.
Yes, Senator. I would now like to turn to allegations that have come to the attention of the Church relating to the corporate, legal and taxation structures of our institution. These allegations originate in the United States and involve a former staff member from the corporate office. It should be noted that these allegations have no basis and have been comprehensively investigated by the IRS. The last involvement of this employee in the legal affairs of the Church was December 1983, approximately 27 years ago. The review undertaken by the IRS took place between 1991 and 93. The Church was given a clean bill of health by the US authorities and the allegations were unfounded. I would now like to turn to the proposed bill. The Church commissioned a leading legal opinion on the proposed legislation that is currently before the Senate committee. It formed the basis of our submission, and Ms McBride appears in her capacity today as a legal specialist on taxation law, and she will be able to assist the committee in regards to details arising from the proposed bill. Suffice to say, the Church believes that the proposed bill is inherently flawed and puts at risk the financial future of charities and religions in Australia. Given the need of brevity, I will not go into the details already covered in the Church's submission tendered to the committee and the comprehensive arguments outlined by Ms McBride as she makes her opening statement. It is significant that already the former coalition government and more recently the Henry Review, commissioned by the Labor government, have investigated the application of a public benefits test, and on both occasions the recommendations have been ignored or rejected by the executive. In appearing before the committee today, we welcome the opportunity to answer questions relating to proposed taxation measures. We wish to assist the committee in its important work in examining the bill and detrimental impact that the proposed bill will have in moving forward. I would like to place on the record the great assistance of numerous senators and members of the Commonwealth Parliament, including the Privileges Committee, Scrutiny of Bills Committee and the Clerk's Office in the lead-up to today's hearing. I would also like to acknowledge the assistance and support of the Committee Secretariat, led by Mr John Hawkins, who provided professional and impartial advice as part of the inquiry process. Finally, given the Senate's well-established role as a House of Review, it is also important to recognise the role the Senate has had and continues to have in maintaining freedom of religion and the promotion of tolerance. We have no doubt that the Senate, in its wisdom, will continue to protect and promote these traditions. Thank you.
Thank you very much. Senator Cameron. You wish to make a statement? Please do so.
I'm in the committee's hands. I have an opening statement that I can actually tender, but there are a few...
No, please proceed. I'm sorry, I didn't realise you were going to make a separate statement, but go ahead, that's fine.
Again, I'd like to thank the committee for giving me leave to appear today in my professional capacity. And in commencing my opening statement, I'd like to make it clear that I'm not a Scientologist. I do not practice Scientology. I've never been to a church that is run by the Scientologists. I am, however, a tax barrister. I have practiced law since 1981. During my career, I have served as a board member of the Takeovers Panel, the Export Finance and Insurance Corporation, the Corporations Market and Advisory Committee, and the Commonwealth Government Superannuation and the Public Sector Superannuation Schemes. I've been retained by the Church to provide my legal opinion on the bill, particularly as it relates to taxation, as I have had a role on the Board of Tax, advising on tax reform generally. I'm also retained in my capacity to advise on constitutional and administrative law issues. My opinion, I believe, has been circulated to the members of the committee, and it is on the website attached. In brief, as I'm sure the committee is aware, I have some major concerns with the bill as presently drafted. The bill, as currently drafted, imposes a taxation and therefore is subject to the limits of Section 53 and Section 55 of the Commonwealth of Australia Constitution. As a bill imposing taxation where none was imposed before, given we've already heard that religions have never been subject to tax in this country, and the Parliament provides that only the House of Representatives may introduce a tax bill, and then it may only be introduced by a Minister of the Crown or a Parliamentary Secretary, and I refer the Senate to, of course, Standing Ordinance 293, I have concern that this bill is in the wrong House, and this point has been raised as a point of order. I understand that the bill has been referred or will be referred to the Constitutional Committee. And I'm not sure if a point of order has been taken as to the propriety of proceeding with this inquiry, given a very significant constitutional issue raised before the
Ms.
committee.
McBride, this bill has been referred to this committee by the Senate, and these hearings are legitimate and have the authority of the Senate.
Thank you, Chair. The bill, nonetheless, is a tax bill, and I refer the committee to former Chief Counsel of the Attorney General's Department's opinion which was dated 30th of August 1993 and was obtained in respect of the Taxation Deficit Reduction Bill 1993. It talks about there is a significant constitutional issue.